I'm Bob Girrier, President of the Pacific Forum, and welcome to our Maritime Discussion Series, our webinar series supported by the U.S. Department of State through the U.S. Embassy in Tokyo and organized in partnership with the Yokosuka Council on Asia-Pacific Studies, or YCAPS. Please note that our session today features simultaneous Japanese interpretation. Please click on the interpretation button or the globe icon at the bottom of your screen. Our discussion today will focus on navigational rights and freedoms, which are key tenets of a secure and stable global maritime order. In the Indo-Pacific, some have sought to unilaterally reinterpret navigational rights and freedoms under international law by imposing new restrictions on movements at sea, such as preconditions for the exercise of innocent passage, prohibition on military operations and other lawful activities in the exclusive economic zones, and discrimination against warships and some of the recommendations being put forward, among others. These efforts impinge on traditional uses of the oceans by other states and are contrary to advancing a predictable, rules-based, free, open, and inclusive Indo-Pacific. Today, we're joined by two experts who provide us with perspectives on these critical issues. Our speakers today are two of the most respected voices on international maritime law, Professor Atsuko Kanehara and Professor James Kraska. Just a little bit about our speakers in more depth, because it's a real treat to have them both with us today. Atsuko Kanehara is Professor of Public International Law at Sophia University. She's also President of the Japanese Society of International Law and Vice President of the Japan Society of Ocean Policy. Professor Kanehara also serves as Counselor of Advisory Council for the National Headquarters for Ocean Policy of Japan, appointed by the Prime Minister. Some of the other positions that she serves in also include, she serves as Counselor of the Sasakawa Peace Foundation. She's also a member of the governing board of IMO International Maritime Law Institute and a visiting lecturer of the IMO International Maritime Law Institute. A wonderful set of qualifications, and it's great to have Professor Kanehara with us. She's joined by James Kraska. He's a chair and Charles H. Stockton Professor of International Maritime Law in the Stockton Center for International Law at the Naval War College. This was the first established chair at the institution. He's also a visiting professor of law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. He has served as a visiting professor of law at the College of Law, University of the Philippines, visiting professor of law at Girrier National Law University. I probably mispronounced that. You can help me on that later, Jim. Mary Derrickson McCurdy, visiting scholar at Duke University Marine Laboratory and fellow in residence at the Marine Policy Center, Woods Hole Oceanographic Institute. So we really have two amazingly distinguished experts joining us today. But before I turn over to our speakers, just a couple of disclaimers. The views expressed by the speakers and myself as moderator do not necessarily reflect the views and official positions of the U.S. Department of State, the U.S. Embassy in Tokyo, or the United States government. All views and opinions expressed in this webinar also do not necessarily reflect the positions of the Pacific Forum or the speaker's home institutions. Finally, all remarks, including those during the question and answer portion, are on the record. We're also live, not just through the Zoom platform, but also on Facebook. So please, just please be mindful of these conditions. Without further ado, I think we'll kick off first with Professor Kanehara. Over to you. You have the floor.
Thank you very much, Bob, for your very kind introduction of me. Let me begin the screen sharing for my PowerPoint slide. Okay. Sorry, the first one. Okay. Sorry for waiting. Thank you so much for waiting for me. Atsuko Kanehara, Professor of International Law and President of the Japanese Society of International Law. I would like to express my sincere gratitude to Pacific Forum and all the organizers. At the beginning, I would like to make clear my understanding of the terminology in the title of today's session, namely navigational rights and freedoms, global rules, regional norms. I think I can get from the title a very interesting perspective for my presentation. As legal parlance, as a lawyer, I have a general impression that norms may have a more flexible implication than rules in terms of strictness for restricting acts. Then, the title says global rules or regional norms. Why? My understanding is that rules are stricter than norms for restricting acts, and that norms consider special contexts and situations more flexibly than rules. My presentation today is based upon such uniquely understood distinction between norms and rules. My presentation consists in the 3 points. First, the freedom of navigation as a general rule. Second, a special implication of regional norms in the South China Sea without excluding the East China Sea. And third, interplay between the global rule and the regional norms to maintain and strengthen both the global and regional maritime order. From the 17th century to the 19th century, the two fundamental legal regimes of the law of the sea were established. They are the High Sea regime and the Territorial Sea regime. Against the backgrounds such as mercantilism, colonialism, the rising power in Europe, such as the Netherlands, UK, and France, claimed the wide oceans for free use. This was the historical protest against the former world hegemons, Spain and Portugal. They had occupied, at least by their paper claims endorsed by the then Pope, all the global sea areas and prohibited the navigation through them by foreign vessels. The rising powers, in order to ensure the sea routes between their lands and colonies, insisted the freedom of seas and the freedom of navigation. After all, by the 19th century, the two legal regimes of oceans were established. The wide high seas and the narrow territorial seas. In that period, with the freedom of fishing, the freedom of navigation was a main pillar of the legal regime of high seas. What is the meaning in saying that the freedom of navigation is the essential element of the legal regime of high seas, particularly in contrast to navigation rights? Next, I will explain the meaning of the freedom of navigation. At high seas, the freedom of navigation principally means non-interruption and non-interference against vessels by states other than flag states. This is the flag state principle. Vessels are flying with the flags of their nationality. In addition, the balancing of the interest of the rivalry sides, namely flag states and coastal states, has continued to be the fundamental requirement for the law of the sea for a very long time, and certainly until now, under UNCLOS, the United Nations Convention on the Law of the Sea. UNCLOS refined the sea zone system by creating new legal regimes of sea areas. Currently, as the jurisdictional sea areas, there are internal waters, territorial seas, contiguous zones, exclusive economic zones, and continental shelf. In these sea areas, UNCLOS provides for a very complicated the right and obligation relationships depending on the legal nature of the sea areas concerned. Let me take examples to explain the rivalry relationship between flag states and coastal or proto-states. First, in territorial seas, foreign vessels have the right of innocent passage. UNCLOS defines innocent passage as passages that are not harmful to peace, order, and security of coastal states of territorial seas. I will take up later the innocent passage in relation to the US freedom of navigation operation. Second, last year, Japan had very unique experience of having the Diamond Princess at Yokohama port of Japan with the infected by COVID-19 on board. Japan, as the port state, seriously considered the relationship between the flag state jurisdiction and the port state jurisdiction. In comparison, in the sea areas between national jurisdiction, principally at high seas, the freedom of navigation and the accompanying the flag state principle are firmly kept. Thus far, in the historical development of the law of the sea, we confirmed the freedom of navigation as the essence of the freedom of high seas. It is explained mainly by non-interruption and non-interference against vessels by states other than flag states. In contrast, these days, as seen in the title of today's discussion, we find frequently the terms navigation rights. Then let's consider the special implication of regional norms in the context and the situations of regions in relation to navigation rights. In this regard, I will focus mainly on the South China Sea. Why in the regional norms in the South China Sea may we choose the terms navigation rights rather than the freedom of navigation? My answer is that the principal weight is placed on actual conduct of navigation more than on the claim on non-interruption and non-interference against vessels by states other than flag states, which means the flag state principle. US has conducted the freedom of navigation of operation. While the name is the freedom of navigation, its significance rather resides in actual conduct of navigation. It can be a typical example of the navigation rights rather than the freedom of navigation focusing on the flag state jurisdiction. Therefore, we might call it the navigation rights presence or navigation rights operation. The navigation rights have been exercised by US in China's territorial seas, certainly, arguendo, in the South China Sea. China unilaterally claims its sovereignty over several islands. The sea areas surrounding the islands would have the status of territorial sea. US is conducted the innocent passage in the territorial seas for the purpose of demonstrating its strong protest against China's requirement of prior permission system for foreign military vessels. Such a prior permission system is unlawful and contrary to the navigation right of foreign vessels that enjoy the right of innocent passage under UNCLOS. Assuming wider sea areas, depending on the legal status of the sea areas, the navigation rights operation bears the significance of demonstrating the navigation right in EEZ or that at high seas. The navigation rights operation may purport to stage, again, a strong protest against China's claim of historic rights over the extravagantly wide sea areas encircled by the so-called 9-dash line. The Arbitral Tribunal in 2016 clearly declared China's historic rights as contrary to UNCLOS. Then, how are the navigation rights placed in the regional norms pertaining to the context and the situations of the South China Sea? As for the context of the region, I can take up the 2 points. First, China's excessive claims over the sea areas based upon its unilateral claim of sovereignty over several islands. Second, the complicated dispute relationships among the coastal states in the South China Sea regarding the sovereignty over the islands. As for the particular situations of the region, the military considerations should be given to China's offensive acts, such as unilaterally constructing military facilities, offensive acts against foreign fishing boats. As the background for the military consideration, the free and open Indo-Pacific view has significantly supported the cooperation among the interested states, including Japan. In addition to the freedom of navigation operation, or I might say the navigation rights operation by US, the presence operations and the strategic communications have been cooperatively conducted. The regional norms for the South China Sea exist in these contexts and situations that are inherent to the region. The navigation rights can be precisely placed under the regional norms. Then, thirdly, I will propose the interplay between the global rules and the regional norms in order to maintain and strengthen both the global and regional maritime orders. First, in the East China Sea, you can see on the PPT slide number 11, China's conducts in the East China Sea. Apparently, they may seem different from those in the South China Sea, but here it is very important for us to remember the 3 main pillars in the red letters on the slide of the rule of law. That is the globally shared common value. Judging from these 3 pillars, China's conduct, both in the East China Sea and the South China Sea, are totally similar to each other, changing the status quo with forcible means, unilateral conduct without seeking peaceful settlement of disputes. Therefore, the analysis of the regional norms in the South China Sea also applies to the East China Sea too. From a global perspective, worldwide concern should be further captured on the China's challenges against the regional norms in the South China Sea and the East China Sea as well. This is because China is challenging really against the rule of law, the globally shared common value. Here, what is the law in terms of the rule of law? Certainly, it can be the global rule on the freedom of navigation established in the long history. The freedom of navigation as a global rule and the navigation rights in the regional norms express the two aspects of the navigation to which the law of the sea has really given one of its most important value. Thus, the freedom of navigation as a global rule and the navigation rights under the regional norms should work properly in conjunction for the purpose of maintaining and strengthening the global and regional maritime orders. This is the end of my remarks. Thank you very much for your very kind attention.
Thank you very much, Professor Kanehara. Jim, you have the floor now. Over to Professor Kraska. Jim, I think you're still muted.
Thank you, Admiral. It's a wonderful opportunity to be able to address Pacific Forum, to see you, hopefully next time in person, and also to see Professor Kanehara, both of you in Newport, Rhode Island again soon. And it's also gratifying to see many colleagues and friends who have joined us today. Thank you to YCAPS and Pacific Forum. This presentation is relatively brief, and hopefully it builds on Professor Kanehara's more comprehensive discussion on regional norms. And what I would like to suggest is that there is a narrative that has developed that is promoted by China, and also some scholars, mainly in the West, that says that there are evolving regional norms, and that those regional norms with regard to the law of the sea have set up certain conflicts, and that all sides both sides primarily in this dispute come into it with clean hands, and it's just simply a difference of views. It's a different or regional way of looking at things. What I would like to do is show a few examples to argue why I believe that this setup is somewhat contrived. We are already familiar with the 2016 arbitration award that also sort of demonstrated that China's claim of some type of special or exceptional rules, in that case, historic rules versus the general international law that the land dominates the sea, was in consideration. Since then, there's been a continued narrative that, to the extent that there are conflicts, in particular between the United States as a country that's not in East Asia and China, that these are rooted in this normative conflict. And indeed, normative conflict is part of international law, but I would suggest that in the case of China, that's not what's going on here. It may be going on with some other countries, but not with China. Let's start with the issue of baselines. As you can see, China is a serial violator of the rules on baselines that are in Part 2, as well as Part 4 of the Law of the Sea Convention. They have numerous straight baselines as a matter of course, rather than as exception. And those baselines often do not adhere to Article 7 in that they do not follow the general direction of the coast. They do not smooth out a deeply indented or cut into coastline or link offshore islands. They're simply dots in the water. Furthermore, there's an unlawful baseline that extends from the mainland of China to close off Hainan Island as some sort of internal waters in the Bay of, in the Tonkin Gulf. Finally, China has purports to violate the rules in Part 4 on archipelagic states by claiming the mid-ocean archipelagos, not just the Paracel Islands that were seized from Vietnam in 1974, but also in over areas that it has no valid claim to, including the Senkaku Islands. China's narrative is that for much of the world, including the United States, that normal baselines indeed do apply. But in the special case of China, there are these additional rules for lavish strait baselines and for mid-ocean archipelagic baselines. The same holds true for the Territorial Sea. And China is quite offended by foreign warships that operate inside its territorial sea in innocent passage. But this sets up the remainder of my few remarks, which I'll end quite shortly. And that is that you notice the first news report is that 5 Chinese warships transited through the United States territorial sea in 2015. China's argument is that while China has laws against foreign warships, the United States does not, and therefore this is a lawful transit on the part of China, even though a similar transit would not be lawful if it were done by the United States. And so that's why you have a dichotomy or a difference between the US reaction, which was nothing out of the ordinary, and China's reaction, which is also often somewhat animated or hyperventilating. But go on to the same set of dynamics with regard to international straits, where China certainly feels that it has the right to transit through numerous Japanese straits, including through the Ryukyu Islands, as well as in this case, in the top graphic, you see the Tsushima Strait, which is 65 miles wide. That's a geographic strait, not a strait under Part 3 of the Law of the Sea Convention. Notice, though, that if a US warship goes through the Taiwan Strait, which is even broader, and also it's a geographic but not a juridical strait, they're both much wider than 24 nautical miles, that causes a reaction by China. China might say again that it's okay to go through the Aleutian Islands or through US straits or Japanese straits because those countries don't have laws that forbid it. But that argument begins to break down when you see the extent of the modern or the contemporary PLA Navy operating in other countries' waters, operating from the Mediterranean Sea all the way through the Indian Ocean and surrounding East Asia, including Australia. So in these cases, there is a regional norm where some states do have rules against military activities in the EEZ. And those apply for the most part for states that are not operating in other countries' EEZs. But that's not the case with China. So you can see here that China is conducting military intelligence operations within the Australian and the New Zealand EEZ, and also in 2013, it began to start operations in the US EEZ. And China might say, yes, but that's because those countries have a permissive regime and we do not. But if you look at further cases, you can see with regard to India, India certainly has a similar type of arrangement or rule set as China. And yet China purports to operate in India's EEZ without seeking prior permission or any sort of consent. And so there's numerous examples of this. And if somebody is enterprising and would like to do the research, I would suggest that of the 15, 16, 17, or 18, depending on how you count them, of the number of states that have restrictions on military activities, these are somewhat contrived in the case of China. And I would suggest in the case of the other larger countries that have naval forces that can project power regionally or sometimes even globally. That is, that those states with China in the lead are taking advantage of the entire suite of freedom of navigation or navigational rights that the United States and Australia and other countries have invoked. And they're doing so in the face of opposition by other regional states that purport to have those laws that are designed to limit their operations. And I'll stop there, and I thank you and look forward to your questions.
Thanks very much, Jim. I think you've both set the table nicely for a rich set of discussions and back and forth, and we've got a little under an hour to do just that, so we've got plenty of time. Let me just run through some of the ground rules here, our procedures. First, to ask a question and or to comment, please use the raise hand function located on the reactions tab at the bottom of your Zoom screen. Wait to be called and unmuted by the Pacific Forum staff before speaking. And please, again, just a reminder, state your name, your position and affiliation before commenting or asking a question. You can also post your question on the Q&A tab. But if you're going to use that Q&A tab, just type in your affiliation, your name. That'll make it helpful because I'm going to be browsing through both of these things as we have this discussion. Let me just jumpstart something really quickly, if I could, for both of our panelists. And let me, the title of this series, talking about international law and regional norms, and you both thankfully addressed it. I'd ask you both, is this a slippery slope? Is it a dangerous trend to try to make that differentiation? On the one hand, you have international law, it is law, and any deviations from it then become contrary to that law. So it certainly eclipses, if you will, norms if those norms are inconsistent. So is it unhelpful or even capricious, I might say, to try to set up a parallel structure that says, yep, there's international law, but there's a set of norms that are a little bit different. And I'll pose that question to Professor Kanehara.
Thank you very much for your question. And for the first, at first, when I saw the title of the today's discussion series, as a lawyer, I had some the misunderstanding. I'm afraid that I had misunderstanding, but actually rule and norm, both words appeared in the title. So I tried to acquire some interesting perspective to make my presentation. And I explained in my presentation that for me, rule is more strict than norms in terms of restricting acts. And to my understanding, norms allow flexible consideration of concrete and regional situations and the context. So based upon this understanding, I made my own presentation. And of course, the maritime order should be global and should be consistent worldwide. But international law has flexibility to allow regional deviation from the global rule. And as a whole, I mean regional rules and global rules. As a whole, they make the international law world. So I made presentation concerning the regional norms, which are pertain to the South China Sea and also the East China Sea as well. And I think it is okay. But the problem is China is challenging to both the regional norms in the South China Sea and East China Sea, and also to the global rule of freedom of navigation. So irrespective of the difference between global rule and regional norms, I think China is challenging to both. So in that sense, China is totally dangerous actor in the world. Thank you.
And Jim, anything you'd like to add?
Thank you. I agree with Professor Kanehara that I view norms as a broader species. I mean, it's a bit of an epistemological question of different international law thinkers describe these differently: regimes, norms, rules. I guess also what I would add about regional norms is that states within regions are permitted to develop regional norms, but those norms only apply as against one another. They don't trump global norms or displace global norms. Yeah.
Thanks very much. I'm going to try to bin some of the questions that are showing up here in the Q&A. I've got two here that are related. One from Richard Dick Mackey, just for all those who don't know, former Sink Pack, we used to call it back in the day, Admiral Mackey. Are we being inconsistent regarding the UNCLOS Treaty when we have not accepted it formally? That's one. And really a partner to that from Thomas Burke. The obvious question, I think, is how important is the U.S. lack of signature to the UNCLOS Treaty when trying to assert violations? So two of these, and I know you know the history, but it'd be nice to share that again to both of you on that. Atsuko, you first.
Thank you very much. And concerning the question whether, especially U.S., which has not yet ratified formally UNCLOS, can utilize, can take advantage of UNCLOS, I think that this and the core of the question is like that. So please allow me to explain a little concerning the legal sources of international law. In international society, there is no legislative organ. There is no authoritative legislative organ. So primary international law is created by two means. First, by treaties. Second, by customary international laws. UNCLOS is a treaty, but you can find that many rules contained in UNCLOS have at the same time the status of customary international law rules. So although the United States, a ratified country of UNCLOS, cannot take advantage of UNCLOS as a treaty, but they can rely on customary international law rules which are contained in UNCLOS. That is my answer to the question of ratification or non-ratification of UNCLOS. Thank you.
And thank you, Professor Kanehara. And I think that essentially was the gist of the presidential proclamation by the Reagan administration back in the early 1980s. James, would you care to add more?
Professor Kanehara said it well, that, and you added that the Reagan March 10th, 1983 statement said that the United States accepted that the law of the sea, for the most part, reflects customary international law, which is no less binding on states than treaty law. It's not worth less in the international system. Customary law is based on state practice, and a sense of legal duty or legal obligation. So I also would agree with that. Now, on the other hand, I think it would be beneficial for the United States to be part of the Law of the Sea Convention, principally because of the extended or outer continental shelf provisions and the deep seabed mining provisions, which are not as, the extended continental shelf is somewhat weaker, I would suggest, than some of the other provisions, particularly the security of legal tenure for outer continental shelf or extended continental shelf development. And then without Part 11, I think it would be very difficult for the United States to participate in deep seabed mining. And so the further you go from shore, the less secure you have of legal tenure. And I think it would be beneficial to lock down those coastal state rights. There is, of course, a diplomatic cost that the United States pays as well. And so to the extent that that's important, and I think it is in some cases more important than others, then that would be beneficial as well.
If I could ask James a follow-up, and again, squarely to Admiral Mackey's question. So we're not inconsistent. It's a matter of, which branch of international law you're choosing to kind of, stack your hands on, in this case, customary. But at what cost, I guess, is really the question. And again, realizing this is a view, I'm asking your opinion. But there's a lively debate, as you well know, and this, many in this audience are part of this debate of the pros and cons of not being signatory, if you will, or having it ratified more properly. And I think the issue then, those that are against the ratification are the concerns about loss of sovereign, autonomy, somehow abridging. Are there answers to that question? How would you answer that question, saying, well, you have to give up some in order to be part of an international system? But are there safeguards in your view to answer those critics?
Absolutely. So I don't agree that there is some sort of loss of sovereignty. If anything, there's security of additional sovereign rights and jurisdiction, or certainty for recognition of sovereign rights and jurisdiction for the outer continental shelf, and then the security of tenure for deep seabed mining sites. So I don't see at all any sort of giving up of sovereignty any more than joining any international organization. I mean, presumably the United States could join and then leave the Law of the Sea Convention if it wanted to. There are some parts of the convention that some that are on the conservative side don't care for. My view would be that the risks actually run the other way. It's not that I will ridicule those concerns. I just don't think that they are, I think they are overshadowed by the benefits. I'll just give one example. That is with regard to the royalties required for outer continental shelf development beyond 200 miles under Article 82 of the convention. And so the argument is that the United States would be funding an international organization. It's not really the UN, but it's a separate international organization, the International Seabed Authority, by providing those royalties under Article 82 beyond 200 miles. The irony is that the United States did not sign UNCLOS, but after Part 11 was revised in the implementing agreement in 1994, President Clinton did sign Part 11. We've never moved forward on it, but we've actually signed the part that it seems that people don't want or don't accept as much, and yet we haven't signed the underlying treaty. So it's a bit of a typical American political mess in that respect. The safeguard with regard to the royalties in Article 82 is that they're actually rather minimal. They were negotiated from the US perspective with the oil industry, with Exxon, and they don't begin until the 5th year of an oil and gas development. Particularly now, it's becoming less and less likely that you're going to have oil and gas development as we shift toward that far out in the ocean as we shift toward other sustainable uses. But even so, or even if there's hard mineral development, those royalties would go to the International Seabed Authority. The United States is the only country in the world that has a guaranteed seat on the council that governs the International Seabed Authority and that distributes those royalties. The council is governed by consensus. And so the United States, always having a seat there, the voting is actually quite favorable. My view would be that it's going to be very difficult for any of those royalties to go to developing countries if the United States seeks to block it. Furthermore, at the end of the day, I would view the royalties from the council as a way to leverage American ideals and to direct those royalties towards states that are strategic partners or budding democracies or in other developing countries or less developed countries that the United States favors. You could always, at the end of the day, reduce your foreign aid budget by whatever amount you're giving to the International Seabed Authority. So I just don't see the parade of horribles that some at the Heritage Foundation or others don't think that their risk assessment is accurate. I don't accept their risk assessment.
Now, I really appreciate this. This is the level of discourse which I really value in this particular panel today, because this is an active discussion that sometimes goes in circles, and it really requires a deep understanding. Atsuko, anything you'd like to add?
No, thank you.
Okay, let me continue. We got several here in the queue, which is wonderful, and I'm gonna try to bin these as we're having this conversation. So let me continue on. Actually, before we get too far away from your original presentation, Atsuko, there is one question here from Kyoko Harakayama, and she's just simply asking, could you clarify again what regional norm is and what is the evidence to show the norm? And I think you were constructing one based on the title of our discussion, but just briefly for Kyoko.
Okay. I hope that I explained that enough in my presentation. So I would like to repeat the gist of my presentation. I explained the special context and situations in the South China Sea. And they can explain particular nature of the regional norms in the South China Sea. It is not a matter of proof, it is a matter of analysis. And also, let me explain from the legal perspective and UNCLOS. UNCLOS has Article 311. It regulates the relationship between UNCLOS and other international agreements. And it does not allow the party states to UNCLOS to deviate from UNCLOS. So as far as the coastal states of the South China Sea are parties to UNCLOS, they are not allowed to deviate from UNCLOS. So we do not have much need to think about deviation by the regional norms from UNCLOS. That is my explanation as a legal expert of international law. Thank you.
Thank you very much. These next two questions are binning together. One is from Bronwyn Davis, a freelance teacher. And thank you for your very interesting presentations. What international legal recourse is available in the situation of China unilaterally claiming South China Sea islands and building military installations on them? So that's one. What recourse is available? And the second question from another joining us here, Narayan Kumar, a lawyer from Mumbai. The question is, how can the international community seek enforcement of the 2016 ITLOS arbitration award? Or is it that the international community is helpless when it comes to enforcing international law against China? So the theme here are what is to be done? How do you enforce, even when you have a ruling by either ITLOS or someone's doing something unilaterally? James, you first, and then we'll pass it to your.
Sure. It's a great question. I would suggest that there's very little in the way of an international community, so to speak. What there are sovereign states in an international system, and they are political actors. And so the only way to approach something like this is it's a foreign policy, it's a political question. And what has been the response? The response has been that the United States and Japan have never had a closer alliance. When I was stationed in Japan, in Yokosuka, decades ago, there was an element that was protesting the US presence. That has evaporated. The United States and Vietnam were in an armed conflict 40 years ago in the lifetime of many of us. That has evaporated. Now the Pew research indicates that the Vietnam public holds a higher opinion of the United States than any country on earth, after we fought a bitter war in which 2 million Vietnamese died in the lifetime of many people today. This is why the United States and India are strategic partners, have already signed agreements to be strategic partners. And it's inevitable that they're moving more and more closely. These are political responses because the law is not going to deliver, or the law is not going to provide a solution to this. The only solution, in my view, it comes from structural realism, and that is that the power structure in the region and the world has moved and is moving to be able to balance China's movements.
Thank you. Professor Kanehara.
Thank you. I totally agree with you, Bob. You connected two questions. First, legal recourse concerning the Chinese offensive acts, and also enforcement of the arbitral award or the judicial judgment. First, concerning legal recourse, party states to UNCLOS are obliged to seek dispute settlement procedure provided for under UNCLOS. So for this reason, Philippines and China both are parties of UNCLOS. Philippines sued against China to the arbitral tribunal, and actually arbitral tribunal rendered judgment July 12th of 2016. And second, then what happened afterwards? China clearly declared that the award is null and void, no meaning, no value. And so how can we enforce this arbitral award? Unfortunately, in international society, there is no authoritative enforcement organ. So we cannot expect the legal enforcement organs. And that is the reason why I today in my presentation emphasized actual conduct of navigation in the South China Sea. Of course, it should be done peacefully, and it has been done peacefully by US. And it is very important, actual conduct, actual presence of navigation lights. And in addition to that, FOIP and rule of law that are worldwide shared common value with the support of rule of law and FOIP with a wider perspective of maritime security. That is not only the core issue of defense or security, the wider perspective of maritime security make cooperative relations with coastal states in the South China Sea. And based upon rule of law and FOIP, worldwide states should cooperate to cope with China's challenging acts to global rule and also regional norms. That is my answer. Of course, I totally agree with James. Thank you.
So we'll continue this thread actually, and the audience, by the way, thank you. Your questions are charting a wonderful path here. So next in the queue, Linda Paul, who's an affiliate, one of our senior affiliates with Pacific Forum. She's a lawyer and specializes in maritime issues. Her question is: China creating new customary international law? I might add to that: is China seeking to create new customary international law, perhaps? But again, Professor Kanehara, you first, and then James.
Okay, thank you very much. Actually, I'm very afraid of the fact that China is abusing the concept of customary international law. Actually, on the occasion of the South China Sea dispute, of course, China was totally absent from the procedure, but China has repeated that its historic rights are based not on UNCLOS, but on customary international law. Are there such customary international rules to justify China's historic rights? The answer is definitely no. In this sense, I'm afraid that China is abusing the concept of customary international law. And under international law doctrines, customary international law can exist by two requirements that are satisfied. First, general practice worldwide. Second, we call it opinio juris, that general practice are conducted and obeyed by many states in the world with a belief that this conduct or the rule reflected in this conduct should be legal rules. So without being satisfied by these requirements, there is no customary international law. So I do not admit that China is creating new customary international law. China is abusing the concept of customary international law. We have to make clear distinction between creation of customary international law and abuse of customary international law. Thank you.
Thank you very much. That's very helpful. James?
Thank you. I agree with Atsuko as well on this. So China, I believe, seeks to create a single exemption because, as I mentioned, China leverages or uses all of the navigational rights and freedoms that it seeks to deny to the United States and Japan and other countries. In particular, China is a geographically disadvantaged country with a very modest exclusive economic zone. China's EEZ is not even in the top 20 largest in the world, unlike the United States, France, Japan, countries that have Indonesia, countries that have very large EEZs. China has a very modest EEZ. This is why they would like to expand it southward and presumably eastward, at least with the continental, or eastward, at least with the continental shelf, or westward. So I think that China seeks to have a one-off exemption for China. And it's not unknown. It's of a different character because China uses coercion and it uses whole of government operations in order to advance its claim, but it's not unknown. It's analogous to Canada, which has unlawful or excessive straight baseline claims around its Arctic islands, or Australia, that somewhat sheepishly seems to claim some type of latent EEZ rights off Antarctica, which of course doesn't have sovereignty over, and so there is no EEZ off Antarctica, which, by the way, underscores that the Spratly Islands some of them or all of them may have no maritime entitlements, because if you can't identify which country has title to the territory, then it's like Antarctica. Antarctica is a continent and it doesn't have a territorial sea or an EZ. So in some, I would agree with what you suggested, Admiral, which is that China would like to help push along the evolution of the law of the sea normatively, but it's not successful so far. It has actually, China is a large country, it's an influential country, it has influenced one state, an ASEAN state that I won't mention, that has been influenced somewhat, not entirely, but somewhat by China with regard to their EEZ law. On the other hand, it's also influenced a number of other states to walk back or change their views or evolve their views away from China. In this case, I would mention states such as Vietnam or India that in either their laws or their practice have become more in line with the global liberal norm. So China is influential, but it's not influential in the same direction all the time.
Thank you very much. Again, this is a really valuable discussion, especially for this group. I mean, if I can just rephrase a little bit or just capture, I think, the sense that as customary law evolves, what I'm hearing from the two experts here is that it's really a participative, it takes both sides, if you will, a degree of assertion and also acquiescence, if you will, but it's not a one-sided coercive element that you just push through, even if some comply or acquiesce due to some coercive conditions. It's much more participative than that, and it doesn't condone unilateral action. In a sense that becomes an oxymoron. I think in this discussion, as you read analysis, articles, people don't get that sometimes. I think they just, and I think it's an important discussion. Again, not putting words in your mouth. You'll have the last word on all discussions here today. But is that a fair assessment, at least, James, that I just outlined?
Yes.
Okay. Let me go with one more. This is actually not in the queue, but it's on the same bin about process and international law. And this is something I've heard Professor Kanehara talk about actually in a previous panel. And it's also something that comes up a lot. And it's what constitutes a lawful dispute. And this is question really, this is my question, but again, it goes back to, there's a set of ground rules, I think, that is out there that often gets subverted or at least misunderstood, that if you object to something and suddenly you call it a dispute, therefore all bets are off, and you can drag an unwilling, a target, if you will, into a quote dispute that you have created unilaterally. Would you care to comment on internationally accepted rules on that, Professor Kanehara? Because I've heard you speak about it before. It's really important, I think, point.
Okay. And as a general principle concerning court procedures, under even current in the 21st century international law society, there is no compulsory jurisdiction of any courts to entertain a dispute of state-to-state relations. So for courts to entertain the dispute between states, courts need agreement from both parties to the dispute. And there is one or two exceptions to this rule. First, under the International Court of Justice, there is a special mechanism to easily obtain the agreement from party state to dispute. And second, under UNCLOS, of course, party states to UNCLOS agreed to this rule, which provides for compulsory dispute settlement mechanism. And the four options, including International Court of Justice, ITROS, and Arbitral Tribunal, and a Special Arbitral Tribunal. Anyway, party states to UNCLOS are obliged by this provision, and so they have to recourse to one of 4 courts or arbitral procedures regarding their dispute. So one of them, or I mean, one of two party states can unilaterally recourse to, for example, ITROS or arbitral tribunal, the dispute with other party state to UNCLOS. That was the case with the South China Sea dispute. Both Philippines and China are party state to UNCLOS, so they are obliged to seek the one of 4 court or arbitral procedures. I think in this sense, there was no fault on the side of Philippines. So I think China had obligation to go to arbitral tribunal. But anyway, China refused it with its influential power in the world, maybe. So anyway, as far as states are party states UNCLOS, the maritime dispute can be entertained by International Court of Justice, ITROS, Arbitral Tribunal, or Special Arbitral Tribunal under UNCLOS. Thank you.
Thanks very much, James. Would you care anything to add? Hard to top Professor Kanehara on that. Thank you again. Our next question is from Kantaro Furuya, who's a professor at GRIPS and the Japan Coast Guard Academy. So his question about the recently enacted Chinese Coast Guard law. It seems to me there are a number of provisions that would be a violation of international law, including law of the sea. What would be the impact of the law in the South and East China Seas? Would the law be an example of Chinese sovereignty in these waters and support China's historical rights in the long term? James, for you first, and then certainly Professor Kanehara. James.
Thank you, Commander Furuya, for the question. Also, look forward to welcoming you back to the Stockton Center. And also, I just wanted to thank Admiral Mackey for the question earlier. I was one of the lawyers for one of his JTFs, JTF 5 or JATF West, for some time when he was the SINCPAC commander. So in my view, the biggest problem with the Coast Guard law is in its use of force provisions, which read as though they permit use of force based upon status. And this is not in accord with rules for the use of force that are predicated on the law of human rights. And you couple that with China's extravagant claims and the large amount of ambiguity that's imbued with those claims. And I think that's what has caused the discomfort from the China Coast Guard law. Thank you.
Thanks, James. And Professor Kanehara.
Thank you very much. On another occasion, I have already made the presentation concerning China's Coast Guard law, and James was present on the panel. And so maybe you remember that. I totally understand that. I know that there are doctrinal or academic criticism concerning China's new Coast Guard law, particularly relating to the following 3 points. First, unclear definition of jurisdictional sea areas. Second, possible use of weapons under the context of law enforcement against foreign public vessels, which totally enjoy the immunity, I might say sovereign immunity under UNCLOS. Third, the use of force or the use of weapons, whether they are contrary to international law standards. I know that these academic discussions are valuable, but I have a little bit different opinion concerning the evaluation of China's Coast Guard law. I think we need to think about it totally in a special context, in a concrete context. So of course, the ambiguous word, jurisdictional sea areas, but actually in what sea areas, what China do, law enforcement or defense? And depending on the context, the evaluation may be different. So I think now we need to consider and analyze the China's Coast Guard law in context, taking up possible and various examples. That is my opinion. Thank you.
Thanks very much. Let me go now to a question from Nadia Elbarai-Yamamura, a retired research scientist. Professor Kanehara brought up the subject of the Diamond Princess. And on board the cruise ship, there were many people from different nationalities, and they were not allowed to leave. So the question is, I'm not familiar with international law, but would the passengers be under Japanese law, or could passengers be protected by their embassies or consulates? Again, specific case of Diamond Princess. To you, Professor.
Thank you very much for very interesting and very important questions. Of course, in Diamond Princess, there are many people who have different nationalities, but Diamond Princess anchored at Yokohama port of Japan. It is Japanese port, and it is in Japanese internal waters. So generally speaking, the vessel, the cruise ship, Diamond Princess, and also passengers and crew on board it are under Japanese jurisdiction. And if it is not the case, Japan could not take efficient measures to prevent further infection of COVID-19. So I think at least during the time when Diamond Princess was at Yokohama port, and still the infection was continuing and ongoing, Japan needed to take strong measures against both Diamond Princess and also crew and passengers as well. For that purpose, I think Japan should have the perfect jurisdiction over vessels and also passengers and crews. Thank you.
Thank you very much. And again, from my knowledge, in this specific context, that's broadly acknowledged. There are not many disputes in this area. You're talking about a ship that's pierside, not underway. It's within territorial limits. In fact, it's in many ways relying on the support services of the host country, but normally not a contested issue at all, I think. Is that correct? Okay, our next two questions, actually, I'm going to link together from Lajani Dai, and who's from the Philippines, and also from Park Presnell. And these questions, the first one from Lajani Dai from the Philippines. My question is that with China, what they've been doing in the West Philippine Sea, okay, in this area to the west, and not following the agreement. So what China's been doing in the West Philippine Sea areas and not following the agreement, I'm assuming UNCLOS, what could be other solutions to resolve this problem, knowing that there's limited capabilities and capacities from the Philippines? So that's one question. Very similar, Park Presnell asks, in your view, are filing claims in international arbitral tribunals sufficient for preserving maritime claims in the context of the South China Sea, especially for for states that face continuous military occupation or activities of paramilitary or, as you know, fishing fleets or and the like? These countries essentially have limited capabilities. So what is to be done? I guess is the question. The different angles on both of these. I'll tip this to James first and then to Professor Kanehara.
Thank you. Great questions. So my view as an international law professor is that these are ultimately questions of high politics. And so the best solutions are going to be political solutions. What can states do? whether this state is the United States, the most powerful country in the world, or the Philippines, or Vietnam, or India, or Japan, or Australia. My view is that like-minded states have to integrate and work more closely together. Each of these states is uniquely situated. For the Philippines, and I know the Philippine Foreign Ministry knows this, as well as Vietnam and Malaysia, they would be strongest if they had a unified view of what are the dissecting the claims in the region. It would make it much harder for states to split ASEAN. It would make it much easier for states outside the region to be able to provide even greater support. So much of this is already going on. Japanese training of the Philippine Coast Guard, combined exercises, United States, Philippines, other relationships that we have China to thank for developing them. Some of that is going on. We could argue whether it's enough or not. My view is that probably more ought to be done and hopefully will be done in order to provide a political balance. To integrate, these states have an alignment of interest and they have to integrate their responses. Finally, I would suggest that Japan is the cornerstone for all security in East Asia, for the entire security architecture, and US extended deterrence with Japan has to be ironclad and unmistakable. And all the states in the region benefit and inure public goods that flow from that US-Japan bilateral partnership. Thanks.
Super. Thank you very much. Atsuko?
Thank you. As I mentioned earlier, there is the legal, at least in some sense, legal solution for the China's offensive and not law-abiding by conduct. But it is not perfect. I mean, even though China and the Philippines both had the obligation to go to arbitral award, China was totally absent from that procedure. And after that, China declared that the arbitral award is totally null and void. That is international society's reality. So in that sense, I totally agree with James concerning political solution. And so, for example, the interested states of the South China Sea, US, or Japan, and Australia, in addition to the coastal states of the South China Sea. The US is conducting the freedom of navigation operation, and Japan and Australia and other countries are conducting presence operation and also strategic communications. And in addition to that, based upon rule of law and FOIP, we need to further capture worldwide concern against China. That is my answer. And I totally agree with James concerning a political solution. Thank you.
Thanks very much. Let's switch topics a little bit. This next question is actually really interesting from Hiroshi Kawamura. Again, it takes us around the world, but what are the legal similarities and differences between China's customary international law issues in the East and South China Seas, so that whole bin, and then Russia's claims over the Crimea and Donbas? Are there similarities there? Are these just apples and oranges, or is there any linkage in terms of their claims? If either of you would care to comment on that. Professor Kanehara.
To avoid any confusion of different issues under international law and international politics, I think we may make a distinction between territorial sovereignty issue and also maritime law issues. So I would like to set aside the territorial sovereignty issue concerning Northern Islands and also Senkaku Islands. And similarity or differences between the legal situation between the East China Sea and South China Sea. As I mentioned in my presentation, Chinese concrete conducts are different between in the East China Sea and also in the South China Sea. But again, I explained in my presentation from the perspective of the three requirements of the rule of law. China's activities are totally similar, both in the East China Sea and also in the South China Sea. I mean, unilateral change, trying to change unilaterally the status quo with forcible means and without seeking any peaceful settlement of dispute. So in this sense, I think we can grasp both the activities in East China Sea and also in South China Sea under the violation against the rule of law. That is my understanding. Thank you.
James, anything you'd like to add?
Yes, I would. So this is a really interesting question. Comparing the different sets of claims. I guess what I would say is that Russia has a stronger claim to Crimea than a legal claim than China has to anywhere beyond its territorial sea. That is a claim of sovereignty. Russia actually has quite a strong claim of sovereignty over Crimea, which was cut out from the Soviet Union just as a political act. And so for Russia to recover that lawfully would be one thing. Now, don't get me wrong, I'm not an apologist for Vladimir Putin or the Russian regime, which I think is an odious and destabilizing regime. They do have a legal claim. And in my view, unfortunately, they might have been successful if they had pursued their cause legally. There are historic and legal connections between Russia and Crimea that are evident. Again, I would connect the law to the political dimension of this, which is, as bad as Putin is, he will not be there forever. And my view would be that there are some other aspects or elements of the relationship that are not present in Russia, that are not present in East Asia. The first is that, in my view, the United States and NATO did a few missteps with Russia that helped to create the problem that we now face. The first was carving out Kosovo from Serbia, getting involved in that war. And when we said we would not create an independent state. And then the second is the expansion of NATO all the way up to the borders and even including former Soviet republics. And I think this was unwise to do it in the 90s, and it was a result, in my view, of hubris. I don't see that in East Asia. My view is that ultimately the groups of states that I mentioned will benefit from and may have to rely on Russia, and not to go easy on Russia or its illegal behavior. But you have to keep in mind that Europe has 2.5 times the population of Russia. They have 10 times the GDP of Russia. They also have 2 independent nuclear deterrents, France and the United Kingdom. If you're looking at the top 5 or so countries in NATO, minus the United States. The situation is flipped in East Asia, where China's population, its economic power, vastly exceeds that of the other 4 or 5 most powerful East Asian states, say Japan, if you count Australia, Korea. Minus the United States, China is much more powerful than those states, and none of them much more powerful in population and in terms of economy right now. And there is no independent nuclear deterrent. So just like Nixon could go to China, I believe at some point the United States and Russia will have some sort of strategic accommodation to deal with China. And I would at least be mindful of that.
Thanks very much, James. We're running out of time here. We're coming up on the top of the hour, but we've got a couple more questions. Let me just run through a few of them. I'll let you choose on which either of you would like to respond to. So one is kind of a pretty overarching from Charlie Brown, who's with Booz Allen Hamilton. And his point is simply, does China's refusal to acknowledge and participate in the permanent court of arbitration, in the tribunal's findings, at least to not even participate, or certainly not to acknowledge it, does that weaken and undermine the success of the UNCLOS regime? And we've both seen some writing about this saying, oh my gosh, it's being stressed beyond its limits and is becoming archaic. I have thoughts on that, strong thoughts, but more importantly are what you think. So that's one. Can this ruin, if you will, UNCLOS? That's one question. One quick question from Narayan Kumar, maybe for Atsuko. He's a lawyer from Mumbai, asking to any specific lights on the Senkaku Islands. In 1 minute or less, right? But anything unique about that, Atsuko, you may want to bring up specifically on Senkakus. And there was one last question, I think, just because we're really near the end here. I think it's more about the severability, if you will. If PRC violates UNCLOS via excessive claims, then would that not be grounds for invalidating its standing to utilize UNCLOS in any jurisdiction of its actions? And that's a technical question. If you're not doing one part, can you then turn around and use other parts of the treaty in some type of severable way, if you will? I'll just leave it at those three questions. Sorry, folks, I can't get to everyone else, but we're really out of time. Either of you like to take a swat at any of those questions I just mentioned?
Just one.
Atsuko, go ahead, please.
Okay,
Thank you.
concerning the Senkaku Islands, because the other two questions were already answered by James and me already. As concerning the Senkaku Islands, I do not argue about the territorial sovereignty issue, but today I explained the China's offensive acts in the East China Sea. One of the typical activity is in the territorial sea surrounding Senkaku Islands. The China dispatching the public vessels, even military vessels, and sometimes several hundreds of fishing boats. And also onboard fishing boats, there are militias. So that is the special the attention on Senkaku Island. Thank you.
Thanks very much. James, you get the back clean up here, sir.
So my final view on this, in taking Charlie Brown's question, is, in my view, states ought to consider and talk about collective countermeasures in order to induce compliance on the part of China. China is a master at exploiting the collective action problem among friends and allies and like-minded states. And so those states have to overcome that collective action problem. And in my view, the best way to do this peaceably is through collective countermeasures. Not allowing China to impose costs individually, but rather to do so. And that means that these states have to find the political will to act together.
Well, thank you very, very much. We're really out of time at the top of the hour. I want to specifically thank our two panelists, true experts, tremendous backgrounds, certainly authoritative on this issue. And I want to really thank you again for bringing this discourse up to a very high level of specificity and accuracy, if you will. And to those of you in the audience, it's almost a charge, because many of you write in pieces and certainly talk about this. And in many ways, you help shape the discussion. And it's, I think, my takeaway, one of my biggest takeaways, I'll simply say, in reflecting over the last hour and a half, is the value of coherence, if you will, coherence of message among the international community. And I think both speakers spoke about that even if you have limited means to fight back, if you will, the real politic of actions that are trying to change the situation on the ground, the value of a coherent voice amongst those that do believe in the rule of law, I think has got, in the end, it must have a consequence, if you will, in creating a good behavior. At least that's certainly an aspiration that has guided global norms in the past. I want to thank again our two panelists. Our next Maritime Discussion Series number 10 will be happening next month, and it'll be on the role of U.S.-Japan alliance in advancing rules-based maritime order. So definitely a continuation of this discussion. Thank you very much for both of you, and thanks everyone for your great questions. Take care.
Thank you, Rob and James. See you again in the near future. Thank you.
Thank you, Atsuko and Bob. Have a
Bye.
nice
Thanks a lot,
Bye.
James. That's Atsuko.